Hey everybody, this is Tracy here with another edition of A View from Tracy's Point. And woo-wee, child. That Jennifer Bonjean is on fire. Jennifer Bonjean should have been in charge of this R. Kelly defense from day one. And the more motions that she files, the more we realize that Steve Greenberg and crew were doing nothing. That they probably were working with the opposition. I mean, Jennifer dropped 2 motions yesterday evening and let us know she dropped those 2 motions yesterday evening. And then sis rolled out, headed to California to help Dr. Cosby with his case. And I also need to bring you guys a video on what's going on with Mr. Cosby's case, because she's exposing the frauds over there as well. And so I need to put that on my long list of videos that I swear for God that I'm about to do. And then I get to playing with my little grandbaby and forget all about YouTube and everything else. So before we get started, we got some housekeeping measures. And so, one, somebody reached out to me and asked me what is the thanks button that now appears underneath my videos. And so the thanks button is a button that YouTubers are eligible for once they reach 10,000 subscribers. But YouTube determines when they give the YouTuber the button. And so I've had 10,000 subscribers for quite some time now, probably for about 2 or 3 years. I crossed the 2 or 3 years ago, I crossed the 10,000 mark. But they didn't give me my thanks button. And there's no rhyme or reason as to when a YouTuber gets that button, because I know people who got it as soon as they hit 10,000 subscribers. YouTube gave them the button. And then people like me, they waited to give the button, because I am about 8 subscribers shy of 14,000 at this point. And I think it may have something to do with whether or not a YouTuber goes live or doesn't go live. And you guys know I don't go live on my channel. I will, however, do a premiere, which gives the appearance of a live stream, but I'm really not live. I'm not doing that in real time. And that gives me the opportunity to edit my content and allows me to be in the chat with you guys, like responding to your questions and whatnot, or clarifying statements that I made. So basically the thanks button is similar to the super chat and the super thanks buttons that you have on live streams and premiere videos, which allows you to give a tip to the YouTube content creator. Except with the thanks button, you can do it anytime, rather, when the video is posted. If you're watching the video, a day, a week, a month later, you can still give the YouTuber a tip. And I have shared before that I don't, although donations to my channel are appreciated, I appreciate all of you who have donated to me, who send me PayPals, who just show up constantly and say thanks, like the videos, leave comments, interact with other people in the comments. All that is appreciated, and all of that is considered support. But the reason you don't see me pushing the super chats and the super thanks, and now this thanks feature, is that YouTube takes 45%. And so if somebody donates $20 to me, I'm only getting $11, and I'm grateful for the $11, but I just like for people to know that when you donate to this channel, that the full amount that you're donating does not come to me, that YouTube does get 45%. So basically the thanks is just another way to tip YouTubers on regular videos. So when you're watching the live stream, you have the super chat and the super thanks. With the thanks button, you get to leave a tip regardless of what point in time that you're actually watching that video. So that was one thing that I was asked. Something else somebody asked me. Oh, my video yesterday, where I talked about Jennifer Bonjean and just giving you guys an update on what was going on with the trial, a motion that Jennifer Bonjean had filed. And someone in the comments, and I went over the alleged victims in the case. I went back to the original indictment, the superseding indictment, and we talked about who the players are in the Northern District of Illinois case. And then we went into the motion that Jennifer Bonjean filed back on April 30th that I told you guys I was going to do a video on, and I finally got to that yesterday. So someone left a comment where they were stating that they believe that Rashona Landfair's cousin is either individual 4 or individual D or minor number 5. And my response to that person was that I believe we are like 99.9% sure that individual D is Lisa Van Allen. And as I pointed out before, Lisa Van Allen was victim number 2, but then they decided to bring in those charges about the extortion and Mr. Kelly trying to buy the videos back and all that stuff. And so 99.9% sure that individual D is Lisa Van Allen, and she's no longer in the indictment as one of the alleged victims. As for one of the alleged victims, so there's 5 victims. There's victim number 1, or minor number 1. I shouldn't say victim because they don't call them victim, they call them minors. So minor number 1, we know it's Rashona Landfair. Then we go down to minor number 3. Minor number 4, we believe 99.9% sure that is Tracy Sampson. And then we have a minor number 5 and a minor number 6. And I believe that people are saying that number 5 may be Rashona's cousin, is because in the whole trickery going on with extorting this money to get these victims back, it states in the record that at some point minor number 5 was in a video with minor number 1 and individual D, which is, we believe, is Lisa Van Allen. So the reason I am saying that this person most likely is not the cousin, and I'm thinking that they're saying that it is the cousin that was in the group for the cause with Rashona and the brother and the other cousin, because it was 4 of them and they were all related. I believe that that's who they're talking about, but I could be wrong, and they may be talking about a whole nother cousin that we don't know anything about. But in any event, if they're talking about the cousin that was in the group for the cause, the only one of the minors listed in the indictment that could possibly be her, and it would be a long stretch, and that would be minor number 3, because then the age would match up, because that cousin's birthday was in May of 1981, which would have placed her at, they said that the alleged incident happened over the summer of 1996, so that would have made her 15 at the time. But minor number 5 was only 13 or 14 when she allegedly met Mr. Kelly, and their alleged relationship lasted from 1998 until 2001, maybe 2001, 2002. I don't have the document here with me, but that would not be the cousin. Shona Edwards would not be that person, simply because of the age. Now, if they're saying that this person who was in this, who met him at the age of 13 or 14 and had this 3-year-long relationship with him, was one of Rashona Landfair's cousins, then that would be interesting. And interesting because I would think that at some point Sparkle would have made it known that, oh, like when she was trying to push the story that Rashona was the one in the video, wouldn't it have made sense for her to say, and he also messed with my little sister or my other cousin, or however this relationship is? Seemed like that information would have come out at some point. And also, why would that person have continued to deal with him after the tape was allegedly revealed to Jim Derogatis? So you guys see what I'm saying? Like, it didn't make sense to me that that person would be a cousin. And the only way that it would make sense now is if they just forced this person to get in this indictment just for the hell of it, just for credibility. And to me, I'm just not feeling that minor number 5 is the cousin of Rashona Landfair. And like I said, the only other cousin that we know of is the girl that was in the group for the cause, and she's actually 3 years older than Rashona. So, and then also I pointed out to the person that Rashona didn't start hanging out with the Kelly family until Drea had Joanne, and Joanne was born in 1998, right? And then Sparkle also talks about the fact that she introduced Mr. Kelly to Rashona in 1998. So why would she make a point to say, hey, I introduced him to my niece in 1998, so the video had to, the earliest that the video would have been created was 1998, because that's when he met her, and that's where they're pulling that date from of when these videos allegedly were made. So it just seems to me if he messed with 2 of her cousins, or the cousin and the sister, however the other girl is related, seemed like she would have pointed out at the time that it was 2 people that he was involved with on these videotapes. Why keep that secret? Why put Rashona out there on blast, but then try to protect the other cousin? So to me, it just didn't make any sense, but that doesn't mean that it is not true. So then we move over to an article that appeared in the New York Daily News. So you guys remember a few weeks ago, maybe a month ago, this guy named Frank James was arrested for a shooting. I think he shot people in the subway. So he's a black guy. Remember, he was a YouTuber. They found all these videos, brought it out. Dude was eating at the McDonald's when they arrested him. So anyway, he's at the same facility that Mr. Kelly is at. And so the media is now trying to say that the 2 of them have this friendship. They've created this bond over there at the MDC. And so this attorney by the name of Joseph Tooley, who has made some interesting posts about the whole United States versus Mr. Kelly, and basically talk about how they railroaded him. And he every now and then he jumps up and makes his comments. And so he made a post the other day where he says press and feds collaborate to present 2 unrelated infamous defendants as quote unquote friends in a quote unquote bromance. Who cares? They're poisoning the jury pool by conflating negative associations into a larger target. Hashtag make justice blind, and remember, innocent until proven guilty. Hashtag Kelly. And so I'm not going to read the article to you, but Jennifer Bonjean, I believe this is the one that has a quote from her. But she stepped in and basically dismissed this notion, that there's any type of friendship. She's like, these are people that are incarcerated. They don't have a choice as to where they're locked up at. Okay, and it may not have been this article because I don't see the quote, but she was quoted in one of the articles about this, where she was basically saying that, as I said, that when people are arrested, they have no choice in who they get locked up with. And she also pointed out that they are not in the same cell together, that Mr. Kelly actually has a private cell. And I thought that was interesting information to know, that he is not housed in an actual room with somebody else, that he is in a cell by himself. But Jennifer Bonjean definitely on it, definitely calling out the hypocrisy and how the media is trying to manipulate the jury pool, and how we're moving into getting a jury selection, because the trial starts on August 1st. So as we get closer and closer to the trial, stuff is starting to ramp up. We can expect to see these articles, that are put out in the media that are trying to taint the jury pool. And, these are attorneys that are making these statements. And so I thought that was something interesting. Now, let's move on to the reason for this video, which is these motions that Jennifer Bonjean posted last night, before she headed out to her case with Bill Cosby and that woman that claimed that she met him at the Playboy Mansion. And I meant to do a video on this. You guys know I have a list, and I pull the information and everything to do these videos, and then I get sidetracked and don't do the video. But I do need to go ahead and do that video about Mr. Cosby and this woman, and how they pulled the manifesto from the Playboy Mansion, and it doesn't show that that woman was ever at the Playboy Mansion, let alone there as a guest of Mr. Cosby. So let's do the short one first. So one of these was 4 pages long, and the other one I believe was 12 pages long. So the first one is a motion. It says Defendant Kelly's motion for production of investigative material developed in connection with the Department of Justice and the FBI investigation of a Bureau of Prisoner officer who stole defendants' confidential prison records, communications, including privileged attorney-client communications. And I thought this was so funny, because in the video I did yesterday, I think I pointed out the fact that, about the information that was contained in those documents, that Rashona Landfair was donating money to Mr. Kelly, putting money on his books, may have been emailing him, and then she drops this motion later on. And I'm not saying that she's watching the YouTube channels and getting inspiration. I just think it was pure coincidence that I talked about that in the video, and then she dropped this motion. So it goes on to say, now comes Robert S. Kelly, defendant, by and through his counsel, Jennifer Bonjean, respectfully moves this court for an order commanding the United States Attorney's Office to produce materials prepared in connection with the government's alleged investigation into Bureau of Prisoner officers who accessed and stole defendants' confidential prison records and communications, including attorney-client communications that were subsequently shared/sold to a blogger who provided/sold that information to unknown numbers of government witnesses. Defendant has a good faith basis to believe that the stolen information was also provided to a government informant who may have shared said information with government witnesses at the behest of the government. Since such information developed during this investigation might constitute impeachment evidence, the government should produce it pursuant to Brady versus Maryland and its progeny. And Brady versus Maryland is a ruling that states that the government has to turn over all evidence, whether it benefits them or benefits the defense. And it's often called, I believe it's the 3500 material. And then the government witness or the government informant who may have got access to this information, we know, is Larry McGee, who was working with the Clary family and was very instrumental in getting Ariel Clary to turn from supportive girlfriend to Jane Doe number 5 in the Eastern District of New York case. So it goes on and says, 1, while defendant was detained in the Chicago MCC between July 15, 2019 through January 8, 2020, access logs showed that 60 60 Bureau of Prison employees access defendants' confidential records. Everybody was up in this man's business accessing his records, but we only know about one of them, who was allowed to retire. She was a long-time federal employee, and they allowed her to retire. And then we know that she gave the information to Tasha K, but nothing happened to Tasha K as a result. So one such Bureau of Prisoner employee accessed defendants' records. Are y'all ready? 153 times, even though that employee was not assigned to the MCC. I want y'all to know that this is equivalent to us YouTubers who have Pacer accounts accessing Pacer during the trial, like just constantly going in there. I had to figure out a way to get this information without, because you're charged 10 cents per page in Pacer. And when I tell you guys, I don't know if I mentioned this before, but in the midst of, so you're billed every 3 months. So I believe for July through September, July 2021 through September 2021, which was leading up to the case in the Eastern District of New York. When them folks sent me my bill for that Pacer account, I almost had a heart attack. It was almost $400, y'all. I was like, Lord Jesus, be offense. Okay. So she was addicted. She was trying to get that information is what I'm trying to say. She, just how we are when we're trying to get these files, these motions and everything, like we're on it. We're like, oh, did they file anything? Did they file anything? And we're in there. But then, honey, after I got that bill, I had to go back and rethink this thing and figure out a way to not trick the system, but learn how to formulate how I want my query to run so that I only get the information that was just loaded, so that I'm not constantly pulling up. So like if there's 100 records or 100 files, I'm not pulling up all 100 files, which is going to give me multiple pages, and I'm charged $3 every time, every day that I go in and check that. So I figured out a formula where I'm only paying like 10 cents here, 30 cents there to get this information. So anyway, she says that woman accessed Mr. Kelly's records 153 times, even though that employee was not assigned to the MCC. And you guys know I did cover that, and I'll try to remember to put the link in this video if you want to go back and check out that information. So number 2, information from those records, including defendants' visitation lists and email communications, including attorney-client communications, were provided to a YouTube blogger named Tasha K. 3, on information and belief, Tasha K shared those stolen communications with government witnesses with an alleged government informant who was under federal indictment at the time the information was stolen, aka Larry McGee, aka Little Grown Boy. 4, the United States Attorney's Office commenced an investigation into the incident that resulted in defendants' communications being stolen and shared with untold individuals. 5, apparently the U.S. Attorney's Office sought a search warrant for the computer used by the Bureau of Prisoner employee, United States versus HP desktop computer 20 MC 148. So I need to go find that. So the application and affidavit in search of the search warrant has been sealed and is not available for public view. Okay, so she basically telling us don't go looking for it because we ain't gonna be able to see it. Thank you, Jennifer. So defendant has never seen the search warrant application and supporting affidavit. 6, the investigation does not seem to have resulted in any arrests, even though it seems straightforward that at least one Bureau of Prisoner officer engaged in official misconduct by accessing unauthorized records and selling those records with third parties. 7. Defendant has learned that his email communications, including communications with his attorneys and third parties, were shared with potential government witnesses, either in this case, or the Eastern District of New York prosecution. 8. If such information was shared with government employees by the government or its agents for the purpose of influencing testimony, and or third-party government informant used the information to influence government testimony, such evidence would constitute exculpatory material to which the defendant is entitled. 9. Defendant must be afforded the opportunity to discover facts that may be used to discredit government witnesses and or show bias and motive on the part of the government witnesses. 10. It is also highly suspicious that no indictment resulted from this clear act of official misconduct amongst other federal crimes. 11. Defendant is entitled to discover who was interviewed as part of this investigation, what information was stolen, whether it included attorney-client phone calls or communications, and whether such information was shared with prosecutors, their agents, or government witnesses. Wherefore, defendant seeks an order from this court commanding the U.S. Attorney's Office to produce the information. Respectfully submitted, Jennifer Bonjean. Now, can somebody please tell me why Steve Greenberg, Nicole Becker, Thomas Farinella, Devereaux Canick, Calvin Scholar, why none of them did this? Why did they just let this slide? Why did nobody talk about this? It makes you go, It makes you think about what was really going on with these attorneys that was representing him. And so we do appreciate Jennifer Bonjean for being on the job and getting this information out there. So before I move on to the second motion, she's going to talk about an article that appeared in the Chicago Sun-Times on March 7th, 2019. So I am going to go ahead and read that article to you guys, and then we'll jump into the motion that she filed regarding this information. And the motion that she filed is to sever Daryl McDavid's case from Mr. Kelly's case in the Northern District of Illinois. So the title of the article was R. Kelly was guilty as hell, singer's prominent lawyer from first trial says. And I believe I did a video on this article back in 2019 when the article initially appeared. So it says, R. Kelly is on TV saying he never did anything illegal with underage girls. I didn't do this stuff, he told Gayle King on CBS. This is not me. Trying to reach over the head of the legal system and speak directly to those who might be in his jury pool, which is his right, I suppose. It says, but Kelly is not the only voice on the matter. There are the alleged victims and the lawyers representing him. They will have their day in court. There is also the past, the 10 counts of aggravated criminal abuse for 4 women he's accused of now or are not the first charges Kelly has faced. In 2008, he was acquitted of CP charges. That case was dragged out over 6 years by a defense team headed by Ed Jensen, a well-known, even notorious Chicago criminal defense attorney. Jensen is still around at 77, though ill, his usual candor honed by the approach of death. And he did die. So that you guys know, he did pass on shortly after his name came up in the pending charges and arrest of Mr. Kelly, which happened after he did that Gayle King interview. And so he's no longer here to defend himself or to speak on this situation. So the article goes on and says, I have bile duct cancer, he said in the panel study of his Deerfield home, terminal cancer. Doctors gave him 90 days to live. That was a year and a half ago, said Jensen. They don't know what they're doing. Perhaps this is a good moment to set the record straight. I've been a lawyer 54 years, 99% criminal cases. I've represented entertainers, represented people connected to organized crime, represented professional criminals. I've represented guilty people. I've represented innocent people. I can say whatever I want, but we've got to do it fast. It would be nice to get it down so somebody knows besides me. And so that was Jensen talking to the reporter. And he says his father was a bail bondsman, and we talked about the profession of posting bond in the 1950s. Then Jensen brought up a certain former client. And he says, when I represented Kelly in Florida, they set the bond at $1 million. We paid the bondsman $100,000. He was out on bond on the Florida case for 3 days, and they made $100,000 because he had to fly back to Chicago because they were going to arrest him here. Any insights into R. Kelly, the man, guilty as hell? Now that's the reporter. And then Jensen replied, he was guilty as hell. I don't think he's done anything inappropriate for years. I'll tell you a secret. I had him go to a doctor to get shots, libido killing shots. That's why he didn't get arrested for anything else. I wondered if this statement, and this is the reporter, I wondered if this statement might violate attorney-client privilege. But 1, Jensen volunteered the information. 2, Kelly is no longer his client. And 3, attorney-client privilege doesn't hold if a client is engaged in ongoing criminality or is perjuring himself. Both might be the case if Kelly is indeed found guilty. Jensen told me this several weeks ago. I sat on it, not wanting to affect potential jurors. Journalists do care about these things, but seeing Kelly yelling on TV, that seems no longer a concern. If he can spin his case, so can others. I decided to check back in with Jensen. Is Kelly tampering with the jury by going on TV? Jensen said, he is. I'm trying to figure out why he did it. I don't know whether his lawyer is an idiot. He might be. So Kelly's current lawyer, Stephen A. Greenberg, insists he is not an idiot, nor trying to affect potential jurors. Then he says, Kelly is a grown man who can respond to these allegations as he sees fit, said Greenberg. He didn't talk about the charges. He didn't talk about cases. He generalized allegations that he is some kind of monster running a cult. This case is so far in the future. Who knows when a trial is going to be? I don't think anyone is trying to tamper or influence the jury. This is not something being orchestrated as some kind of defense trick. And that was the end of the quote. Then the reporter says, I wondered if Jensen now feels ambivalent about keeping Kelly out of prison. And so then Jensen picks up and says, I didn't facilitate him. He had already done what he'd done. I did facilitate him in the sense I kept him out of trouble for 10 years. I was vetting his records. I listened to them. Which ones would make a judge mad? That's why Jensen said he knew Kelly was attracted to young girls because of lyrics Jensen kept Kelly from using. I was riding in the car listening to a song and said, are you crazy? This is all I need. He rewrote it. Which song? Ignition, Jensen said. It's a song related to a guy driving around in a car with his girlfriend. It was originally a high school instructor in a class teaching people how to drive a car. I changed the words. Jensen said Kelly, while a tremendous talent capable of writing hit songs, is not a very bright person and might have become reckless after beating the rap in Florida. What he didn't understand is this. If you win a case with somebody, they think they're bulletproof, Jensen said. You're almost better off, sort of, losing. He thinks he can do whatever the hell he wants. He has done everything he can to hurt himself. Now, I know you guys are probably wondering, why are you reading this article? Because it makes Mr. Kelly look bad. It's egregious. Like, oh my God, why are you reading this? Well, now I am going to get into the motion that Jennifer Bonjean filed, and you'll understand why I read it and why it is of importance. So this, hold on a second. Okay, so this motion is 12 pages long. And it says Defendant Kelly's motion to sever his trial from co-defendant McDavid's and further to sever counts 10 through 13 from the remainder of the indictment. And you guys remember when I did the last video where I talked about the hearing, it came up in the hearing where Jennifer Bonjean, raised her concerns about Darren McDavid not sharing information, that his attorney wasn't talking to her or to the June Brown guy attorney, who was another person in this case, and she was just trying to figure out like what is going on, what's up with Darren McDavid. And then I also want to point out, someone shared on Twitter, and I want to give them credit, but I didn't write it down, so I do apologize. But someone did share on Twitter that the guy who is representing Darren McDavid had a case before Judge Linen-Weber, and that Judge Linen-Weber sided in favor of this attorney. The attorney was being accused of something, and I wasn't sure whether or not that had any relevance to Mr. Kelly's case. Like if a judge finds someone not guilty or acquits them or doesn't let charges go through against that attorney, should that attorney never be allowed to bring a case before that judge, represent somebody before that judge? I'm not sure if it works that way. I think it depends on the case, what the charges were, blah, blah, blah. And so that may be why he is still allowed, Judge Linen-Weber, is still allowed to be over this case. So it goes on in the first section. It says, remainder of indictment. Now comes defendant Robert S. Kelly by and through his counsel, Jennifer Bonjean, and moves this court to sever his trial from that of his co-defendant, Darren McDavid, with a serious risk exists, where a serious risk exists that a joint trial would compromise the rights of either or both defendants or prevent a jury from making a reliable judgment about guilt or innocence as to counts 5 through 8 in the indictment. Defendant moves to sever on the grounds that one of McDavid's attorneys, Vadim Glasman, is laboring under a potential conflict of interest that may prejudice defendant at trial. Separately, defendant moves to sever counts 10 through 13 of the indictment from the remaining counts where defendant will suffer substantial prejudice if those counts are tried with the remaining counts in the indictment. So she says, A, motion to sever trial from McDavid's trial. 1. Defendant Kelly and McDavid are charged with conspiracy to knowingly alter, destroy, mutilate, conceal, cover up, falsity, and I think that might be falsify, and make a false entry into any record, document, and tangible object with the intent to impede, obstruct, and influence the investigation and proper administration of any matter within the jurisdiction of the United States in violation of United States Code 18, Title 18, United States Code 1519, the obstruction of justice count. 2. The government identifies a number of overt acts in furtherance of this conspiracy, including but not limited to: 1. Kelly caused a Bass Productions Limited check signed by McDavid to be issued to minor one's father, who we know is Greg Landfair. Minor one is Rishona Landfair, in the amount of $30,000. 2. Kelly and McDavid caused a wire to be made from a Bass Productions Ltd bank account to pay a individual B to settle lawsuit that individual B had filed for payment for recovering and returning videotapes that depicted Kelly engaged in contact with Rishona that had been stolen from him by individual D. So we know individual D is Lisa Van Allen. Oh, no, we're 99.9% sure that individual D is Lisa Van Allen. Individual 4, why do I keep saying 4? Individual B is either Yule Brown or Damon Friar, who were both in a relationship with Lisa Van Allen at some point. So 3, Kelly caused a wire transfer in the amount of $80,000 to be paid to McDavid through his firm, Winkler and McDavid Ltd. in September 2014. 4, Kelly caused a RSK Enterprise LLC check to be issued to Rashona in the amount of $1,150 in October 2014. And 5, Kelly caused a wire payment in the amount of $100,000 to be made from RSK Enterprises LLC to agent of McDavid on McDavid's behalf. So 3, separately, defendant Kelly and McDavid are charged with conspiring to receive CP, namely video 2, video 3, and video 4, count 6, and the completed offenses of receiving CP, counts 7 and 8. 4, because many of the overt acts identified by the government involve McDavid's conduct and not defendants' defense as to counts 5 through 8 will turn, at least in part, on whether he possessed knowledge about certain acts that McDavid took. Although McDavid has declined to discuss his defense with undersigned counsel, it seems obvious that defendant and McDavid's defenses are necessarily antagonistic. Indeed, several of the overt acts that the government contends were committed in furtherance of a conspiracy are evidence of McDavid stealing from defendant, which he did for over a decade, not conspiring to obstruct justice. 5. Federal Rule of Criminal Procedure 8B provides that an indictment may charge 2 or more defendants if they are alleged to have participated in the same act or transaction, or in the same series of act or transaction, or in the same series of acts or transactions constituting an offense or offenses. Federal Rules of Criminal Procedure 8B, and that was a quote from that. The rule further provides that, quote, the defendants may be charged in 1 or more counts together or separated, and that all defendants need not be charged in each count. 6. Defendant does not allege that the defendants were improperly joined, but argues that severance is justified pursuant to Rule 14A, which provides that if the joinder of offenses or defendants, quote, appear to prejudice a defendant or the government, end quote, the court, quote, may order separate trials or trials of counts, sever the defendant's trials, or provide any other relief that justice requires. Federal Rules of Procedure 14A. 7. The court should grant severance to properly joined defendants, quote, only if there is a serious risk that a joint trial would compromise a specific trial right of one of the defendants or prevent a jury from making a reliable judgment about guilt or innocence. And then she quotes a case, Zafiro versus United States, which was heard in 1993. 8. A serious risk is present. The Supreme Court has explained if 1, highly prejudicial evidence that is probative of the defendant's guilt is admitted solely against a co-defendant, and 2, many defendants are tried together in a complicated case where the defendants have markedly different degrees of culpability, or 3, essential exculpatory evidence for one defendant would be admissible in a solo trial but unavailable in a joint trial. 9. Defendant and McDavid have mutually antagonistic defenses such that the acceptance of one defendant's defense will preclude acquittal of the other defendant. United States versus Carrillo, which was heard in the 7th Circuit, 2006. Furthermore, Because Kelly has every intention of presenting evidence that McDavid embezzled and defrauded Kelly, along with a host of other employees, McDavid's right not to be tried on crimes other than those charged in the indictment may be compromised. This evidence constitutes essential exculpatory evidence for the defendant, but may not be able to him at a joint trial if McDavid moves to bar it. So, child, she about to expose. We've been hearing for years and years and years about how Daryl McDavid was stealing all this man money, and hopefully there's a forensic accountant on the payroll right now who is going to, connect the dots and show exactly how that happened. So, number 10. Furthermore, there has been no assurances that McDavid will not be used as a witness against defendant in connection with the other charged offenses if he takes the stand. In fact, it seems likely that the government will attempt to use McDavid as its witness if he takes the stand to prevent evidence against defendant as to other counts of the indictment. This might also be true as to co-defendant Brown, since several of the government's witnesses seem to suggest that Brown was involved in facilitating defendants' exploitation of them, a claim that the defendant denies. 11. It is well known and supported by both witness testimony and financial records that defendant was largely ignorant of his finances and relied entirely on his surrogates, including McDavid, to make decisions about how monies were paid and who monies were paid to. It is also well known that Kelly is functionally illiterate and relied entirely on third parties to run almost every aspect of his life that related to business and legal matters. Kelly did not monitor his business accounts and did not write checks from his accounts unless directed to do so by McDavid. Indeed, McDavid created business accounts and secured credit cards that Kelly did not even know existed. Kelly rarely, if ever, used credit cards or debit cards and would make purchases in cash that was provided to him by McDavid. So Daryl McDavid had the poor man out here living off an allowance, having to come to him and ask for money to spend, probably using cash that was given to him following concerts and shows. You know how you you have a concert in a city and then you go to the club as part of a promotion, and they're probably paying in cash, giving him his $5,000 or $10,000 for showing up in cash, and that's what he was living off of. So 13, until McDavid left Kelly's employ, he controlled Kelly's finances in every respect. McDavid used Kelly's business accounts as a personal piggy bank. 14. McDavid routinely wrote checks to himself, and that's wired/wrote checks to himself and his own company, Winkler and McDavid, from Kelly's business accounts without Kelly's knowledge. McDavid paid his personal credit cards from Kelly's business accounts and used his company credit card and American Express Centurion card, aka a Blight card, for personal travel and personal expenses, just living off the man. 15. McDavid induced Kelly to pay him hundreds of thousands of dollars on the false promise that the money would be invested in a popular Chicago restaurant. And guys, I can't remember the name of that restaurant. Oh my God, I hate when I get into the video and can't. Okay, hold on a second. Let me Google, because Google is our friend. Okay, I did come across, is it the Mercadito restaurant? Because here's one article from 2013. It says, home of Mercadito restaurant refinance, a venture managed by local developer Daryl McDavid, borrowed $1.3 million from Chicago-based Lakeside Bank to refinance the Winston Tate building, home to Mercadito restaurant in River North. The new loan, which matures in 2015 and bears an interest rate of 5%, replaces an earlier mortgage from Lakeside Bank from a maximum amount of $3 million and interest rate of 5.75%. According to Mr. McDavid and county property records, Mr. McDavid, who acquired the property in 1997, said the 18,750 square foot loft building at 108-110 West Kinsey is fully occupied, including second floor space that serves as the commercial division of Snadero Chicago, a local distributor of high-end Italian cabinetry. A Lakeside Bank representative did not return our call. And then here's another article, an excerpt from an article that was in CBS News back in 2019 when everything hit the fan. It says Darryl McDavid, one, beginning in the early 1990s, McDavid worked as Kelly's business manager. He ended the relationship in 2013 amid a dispute over unpaid wages. He later sued Kelly for more than $1 million. Two, McDavid has been quick to challenge Kelly's many accusers. During Kelly's 2008 trial, after Lisa Van Allen testified against Kelly, McDavid called Van Allen an admitted thief and liar who wouldn't know the truth if she tripped over it. Three, he also lashed out at another Kelly accuser, Geronda Pace, threatening to sue her for violating a confidentiality clause in her settlement with Kelly after she appeared in the documentary Surviving Lies. Four, in the new indictment filed in federal court Thursday, McDavid is accused of helping cover up Kelly's alleged crimes, paying hush money to victims, and collecting incriminating tapes of Kelly to prevent their release. Let's see, five, McDavid pleaded not guilty to each of the federal charges against him on Friday and was released on a $500,000 bond. He's due back in court next week. And then a little info on Milton June Brown's involvement. And I'm going to get back to the motion. I was just trying to find some information on that restaurant and stumbled across this and thought you guys might want to know. Some people may not know this information, so it may help them. One, Brown has worked for Kelly since the 1990s, while federal prosecutors said he stopped working for Kelly in 2018. A source tells CBS 2 that Brown served as Kelly's personal assistant, among other roles, and still helps when needed. Two, he currently lives in Las Vegas. Three, Brown is named in 2 counts of the 13-count indictment against Kelly, namely the counts alleging Kelly paid Brown and McDavid to cover up his alleged crimes. 4, according to the indictment, Brown conspired to receive 3 videos containing CP. 5, unlike McDavid, Brown is not accused of directly helping cover up the alleged crimes, whereas McDavid is charged with offering hush money to keep potential accusers quiet. McDavid's name is mentioned only a handful of times in the indictment, and I think they meant to say Brown's name was only mentioned a handful of times. And then 6, Brown did not appear in court Friday. Unlike Kelly and McDavid, he's scheduled to appear in court next week. And you guys, I've told you several times before that Milton Brown has some significant health issues. So it will be interesting to see if he's even able to appear in court once the trial starts, or if it will be via video conference. So anyway, let me get back on pace here. I was just trying to find out about that restaurant. So if it's not the restaurant that I mentioned, wait, hold on a second. Sorry about that. I hate when I'm on a website and then all of a sudden the video starts playing. So anyway, back to the motion that Jennifer Bonjean filed. So we left off at number 15. McDavid induced Kelly to pay him hundreds of thousands of dollars on the false promise that the money would be invested in a popular Chicago restaurant. McDavid embezzled the money instead, using it to invest himself in the restaurant while cutting defendant out. McDavid knew that the defendant was powerless to expose this criminal conduct due to his intellectual and educational limitations. So basically what she's saying there is that he got the money from Mr. Kelly saying, oh, we're going to invest in this popular restaurant. And then I just read to you guys that the restaurant, the article that I found, this was in 1997, and he used $1.3 million to buy this building to open this restaurant. And so I'm assuming that Mr. Kelly that this was $1.3 million from Mr. Kelly. He was thinking that he was going to like be an owner or have some form of ownership. And it turned out that McDavid put everything in his own name and that Mr. Kelly had no ownership and no benefit from this business. So 16, McDavid contends that payments made to him by defendant in 2014 and 2015 were wholly unrelated to any alleged conspiracy. Kelly agrees on this point. Rather, Kelly contends that McDavid sued Kelly for breach of contract, a contract Kelly was tricked and manipulated into signing by McDavid. 17. Defendant denies that he carried out any overt acts in furtherance of any conspiracy, and that to the extent the government shows that any monies flowed to third parties from his accounts is largely without his knowledge and carried out by McDavid. Kelly will also show that McDavid had a strong interest in ensuring that Kelly, his workhorse, kept performing so that his personal piggy bank remained full. 18. Defendant does not merely intend to engage in blame shifting. He fully intends to show that McDavid had an independent interest in ensuring that defendant continued to work uninterrupted by bad press because McDavid supported his own lavish lifestyle by stealing from Mr. Kelly. 19. Equally problematic, one of McDavid's lawyers, Vadim, okay, and this is where the article comes into play, the article that I read you from the former attorney who has since passed away. This is where that comes into play, why that was important for me to read that condemning article. Equally problematic, one of McDavid's lawyers, Vadim Glasman, may have a potential conflict of interest and would serve to prejudice Kelly at joint trial. 20. According to the government's indictment, Kelly and McDavid, along with individual A, conspired inter alia to obstruct justice in connection with the Cook County State's Attorney's Office prosecution of defendant in 2008 relating to defendant's alleged creation of CP involving Roshona. 21. According to the government, Kelly, McDavid, and individual A, who was a private investigator used by Kelly's prior attorney, Ed Jensen, agreed to collect videotapes that allegedly depicted Kelly having contact with Roshona. So they was just dirty. 22. According to the government, individual A, who was the private investigator who worked with Kelly's legal team, allegedly agreed to pay money to victims and witnesses and others to ensure that they did not cooperate with law enforcement. Individual A also allegedly arranged for individual B to be paid hundreds of thousands of dollars for obtaining and returning videotapes that depicted Kelly having contact with a minor. And so let's stick a pin here, because remember during the Eastern District of New York, they were talking about all these bribes and how they paid people off during the 2008 trial. And we were like, wait, what? Huh? What are you talking about? So now we know that this is what they were talking about, was this individual A and working with the attorneys, and now Darryl McDavid's attorney. They were all in cahoots doing all this stuff behind Mr. Kelly's back, and he had no clue what was going on. So 23, according to investigative reports, the conspiracies charged in counts 5 and 6 of the indictment occurred in part in the law offices of Ed Jensen, and that the completed crime of receiving CP as alleged in counts 7 and 8 of the indictment took place in Jensen's office also. Wow. 24. Represented by Ed Jensen, Kelly was acquitted in all CP charges on June 13, 2008. 25. For at least the next 10 years, probably much longer, Jensen and Kelly maintained an attorney-client relationship. Indeed, in a Sun-Times report published shortly before Jensen's death, Jensen publicly claimed, quote, "I kept him out of trouble for 10 years, end quote. Jensen stated that he, quote, vetted Kelly's records, end quote. He stated, quote, "I listened to them, which ones would make a judge mad," end quote. And then they dropped the link in of the article that I read to you all at the beginning of this video. So 26, Jensen further claimed that he kept Kelly out of trouble because he convinced Kelly to take medication to suppress his sexual urges. And I guess that's the same medication that they be putting in the food, the inmates' food when they be locked up. I don't know. 27. In the years following Kelly's acquittal, Kelly and Jensen maintained an attorney-client relationship. Also, during that time, Vadim Glasman, McDavid's attorney, worked for Jensen as an associate. An attorney-client relationship between Kelly and Jensen was imputed to Glasman, who was Jensen's associate. 28. According to Mr. Glasman's LinkedIn page, he worked as an associate for Jensen between February 2012 and September 2018. Glasman states on his website that he, quote, began his legal career working hand in hand with Ed Jensen, the Dean of Chicago Criminal Defense. Ed Jensen taught Mr. Glasman his in-depth knowledge of trial procedure and how to craft a defense focused on the specific dynamics of the jury and judges involved. And then it has a note at the bottom that says, sadly, prior to his death, Jensen engaged in egregious violations of the rules of professional responsibility, announcing to the world privileged communications with Mr. Kelly and betraying his duty of loyalty to Kelly in a bizarre interview with the Sun-Times. Much like the government's indifference to investigating a BOP officer's egregious conduct of stealing and selling Kelly's email communications. The ARDC did not seem to have any appetite for addressing an outrageous ethical violation of the storied Chicago defense attorney, Ed Jensen, who, if alive, would have much to explain about his own conduct in connection with counts 5 through 8 of his indictment. So I guess Jennifer is saying that Ed Jensen orchestrated all the trying to pay off these people. Like, I just can't even believe well, I can because it's coming out of Chicago. Never mind. 29. Based on the foregoing, any privileged information conveyed to Kelly to his prior attorney, Ed Jensen, was also received by Jensen's associate, Mr. Glasman, either actually or constructively. 30. Because Glasman arguably owes a duty of loyalty to Kelly because he was a member of the firm that represented Kelly, he is in a conflicted position. The potential conflict may be an actual conflict if Glasman possesses privileged information that he may or can use to the benefit of his client or to the detriment of Mr. Kelly at a joint trial. And then she moves into part B, which is motion to sever counts 10 through 13. And it says 31. In addition to the CP counts involving Rishona, conspiracy to obstruct justice related to Rishona. Now in the document she's saying minor one, but for clarity in this video, we're giving the name since everybody already know who she is. It says the receiving CP counts also related to Rishona and one count of exploitation of Rishona. Kelly is charged with 4 additional counts of exploitation related to minors 3 through 6, charged in counts 10 through 13 of the indictment. 32 counts 10 through 13, which do not involve Rishona, should be severed from the remainder of the indictment because Kelly will suffer substantial prejudice if those counts are tried with the remaining counts in the indictment. And so basically what she's saying, well, I'll continue to read because I've already read the document, so I know what she's saying, but I'll continue to read and then we'll talk about it. 33, Federal Rules of Criminal Procedure 8 allows for joinder of counts where offenses are, quote, of the same or similar character, or are based on the same act or transaction, or are connected with or constitute parts of a common scheme or plan. However, Rule 14, Relief of Prejudicial Joinder, provides for severance in cases of substantial prejudice. See United States versus Warner, 2nd Circuit, 1980. And then she quotes A, relief, if the joinder of offenses of defendants in an indictment and information or a consolidation for trial appears to prejudice a defendant or the government, the court may order separate trials of counts, sever the defendant's trials, or provide any other relief that justice requires. 34. Counts have recognized that substantial prejudice results from joining charges that are supported by relatively strong evidence with charges supported by much weaker evidence. And then she cites several cases. That one was United States versus Alvarado, which was in the 4th Circuit in 1976. And then she says, where difference in the strength of two cases was great, we cannot presume that the jury adhered to limiting instructions and properly segregated the evidence into separate intellectual boxes. United States versus Rajanati, and I'm sure I am pronouncing that very wrong. So let's go back and look at that again, as I have lost my place. I'm trying to get back up here. Oh my God. Rajiante, I think is what it is. 9th Circuit in 1975, reversing trial court's determination that severance was not required where there was strong evidence of robbery and weak evidence of another. Gregory versus United States, D.C. Circuit, 1966. So basically, so I thought she explained it. Oh, okay, so this is where she gets into the explanation. 35. In this case, counts 1 through 3 of the indictment are allegedly supported by video recorded evidence, while counts 10 through 13 are not. Assuming the integrity of that video evidence, which is only an assumption for the purposes of this motion, such evidence would be significantly stronger than 25-year-old testimonial evidence of questionable veracity. It is simply undeniable that the government's evidence as to counts 1 through 3 of the indictment is dramatically stronger than it is evidence as to counts 10 through 13 of the indictment. Similarly, substantial prejudice can result where a defendant has important testimony to give on one case and a strong need to refrain from testifying on the other. And then she cites several cases. And then she points out that in the one case, which was Baker versus United States, which was heard in D.C. Circuit 1968, she says prejudice may develop when an accused wishes to testify on one but not the other of two joined offenses which are clearly distinct in time, place, and evidence. His decision whether to testify will reflect a balancing of several factors with respect to each count. The evidence against him, and this is not Mr. Kelly, this is somebody in a whole nother case. She's quoting from a ruling by the district or from the circuit court on this person's case. Whether to testify will reflect a balancing of several factors with respect to each count. The evidence against him, the availability of defense evidence other than his testimony, the plausibility and substantiability of his testimony, the process effects of demeanor, impeachment, and cross-examination. But if the two charges are joined for trial, it is not possible for him to weigh these factors separately as to each count. If he testifies on one count, he runs the risk that any adverse effects will influence the jury's consideration of the other count. Thus, he bears the risk on both counts, although he may benefit on only one. Moreover, a defendant's silence on one count should be damaging in the face of his express denial of the other. Thus, he may be coerced into testifying on the count upon which he wished to remain silent. It is not necessary to decide whether this invades his constitutional right to remain silent, since we think it constitutes prejudice within the remaining Rule 14, Baker versus United States, and that was heard in D.C. Circuit 1968. Recognizing that sometimes circumstances can coerce a defendant into testifying on a count upon which he wishes to remain silent. And then 38. In light of the foregoing, this court should sever counts 10 through 13 of the indictment where defendant has critical testimony to offer in defense as to those counts, but may seek to maintain his Fifth Amendment rights in connection with counts 1 through 3 of the indictment for which there is substantially more evidence. Indeed, this is precisely the scenario that justifies severance, because defendant has important testimony to give concerning counts 10 through 13 and a need to refrain from testifying as to counts 1 through 3. So, child, it looks like he is going to take the stand, perhaps, involving minors 3, 4, 5, and 6. That should be interesting. 39. Severance is particularly justified here where the only similarity between counts 10 through 13 and the remaining counts of the indictment are that they are of the same or similar character. And she's quoting United States versus Coleman, which was heard in the Seventh Circuit in 1994 and overruled on other grounds. And then 40, counts 10 through 13 are of a similar character. Okay, hold on. I lost my place again. Y'all know I am notorious for losing my place. Where were we at? Let's see. Do not involve. Okay, where was I at? Oh, I hate when this happens. Because I don't think... Okay, I'm going to pick up at 34. I'm not sure if that's... Okay, I think I read that already. I'm sorry. Was supported by video recorded evidence. Counts 10 through 13 did not. Okay. 36. I read that. 37. In Baker, the D.C. Circuit observed. And I read that. 38. In light of the foregoing, this court should sever counts 10 through 13 of the indictment where defendant has critical testimony to offer in defense. And I think I read that because I said he might testify. 39, severance is particularly justified here where the only similarity between counts 10 through 13. I read that. 40, counts 10 through 13 are of a similar character to the counts involving minor 1, but they involve different victims, different acts, and largely different evidence. But because of the similar nature to the counts involving Rashona, the risk of prejudice is acute. 41. It is inevitable that if the jury concludes that defendant is guilty of counts 1 through 3, for which there is arguably stronger evidence, it will not bother to consider whether the government satisfied its burden in connection with counts 10 through 13, counts that each carry a maximum sentence of life imprisonment. 42. Because of the serious risk of prejudice to defendant, this court should grant severance of counts 10 through 13. Conclusion: for the foregoing reasons, defendant respectfully ask the court to sever his trial from co-defendants McDavid's trial and further to sever counts 10 through 13 from the remainder of the indictment. Respectfully submitted, Jennifer Bonjean. So in summary, what she is saying is the only videotapes that they appear to have at this point are those that I guess, what's his name, Alvanetti presented. So remember, he was claiming to have these new videotapes and what have you. Well, those are the only tapes they have, and those tapes only include, allegedly, minor number 1, which is Rashona Landfair. And so we don't know if it is a one tape that has been chopped up into 4 separate tapes. We don't know if they are 4 tapes that involve multiple days, multiple instances at this point. And then when I read the other document in the other video, I thought they said that there was some point that minor 5 was in one of those tapes, and she doesn't mention that in this particular motion that she's filing. But in essence, what she's saying is, if you put these cases together and you show the jury these videos between him and this alleged minor Rashona, then the people are going to find him guilty of all the charges, that they don't care what evidence, that the videos would be so prejudicial that it wouldn't matter what was said regarding these other 4 people. They're going to find him guilty on all charges, that shock value, and that the government is basically piling on these other cases to strengthen what they really are going through and going after, which is trying to get him guilty on that 2008 case in which he was found not guilty. And so I think she makes a good case. It would be, once again, it's up to the judge to decide. Of course, the government is going to respond, and I will be checking to see if they've responded to the other motions yet. They had until the 24th to submit their response, and usually they drop the response on the due date, like many of us do with our coursework at school. We wait until the very last minute to submit the information to the teacher, to submit the work to the teacher. And that's what these prosecutors and lawyers do. They take every minute, every second, okay, to get in whatever it is that they need to say. And so, guys, that's it for me. It was a lot, I know, but interesting nonetheless. We are seeing such a different defense with Jennifer Bonjean than we ever could have imagined with Steve Greenberg and the rest of those clowns. And I'm just happy she's on board, whether it gets the desired results or not. It's just happiness. It's just a good feeling that there's somebody on the case that actually seems to care, that is actually working hard to help him, based on these charges. And how the government is just digging way back. It is just amazing to me. But anyway, that's it. And then I don't know if I mentioned before, I did get the 88-page indictment on the rappers Gunna and Young Thug. And I'm just debating if I want to get into another big case like this. So you guys let me know if you're interested in that case. Let me know in the comments. If you don't care, you're just focused on this case, let me know. And then I might also put a poll out or something on Twitter asking people if they want me to cover that case or not. I got the indictment, but I didn't read it yet. I'll find some time to read it to see if it's even interesting enough to me to cover. Because I really don't follow either one of those rappers. So in any event, that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.